Welcome, and thank you for joining today's call. All lines are in listen-only mode. This call is being recorded. If you have any objections, please disconnect now. We will be taking questions towards the end of the call, and today's presentation will be shared after the call concludes. With that, I'll turn it over to our host, Sujatha Vishwanathan. Sujatha?
Thank you, Cass. Good afternoon, everyone. Thank you so much for taking the time to join us on today's service information session. I have with me what I call our dream team to help all of you for the questions you may have. Ben Gottheim, our Senior Director of Policy, Ryan McGinnis, our Director of Policy, Shubha Porker, our Senior Director of Non-Performing Loans, and John Felix, our Senior Director of Performing Loans, are all here to help with any questions you may have. In addition, we also have Brenda Short, who's going to provide an update on PAID, our expense reimbursement tool, which is going to go live in September, as well as Jonathan Nolte, who joins us from the NPL team to walk us through a little bit on how to submit a FlexMod and Workout Prospector, given our recent announcements for the changes in the product, in the FlexMod, as it relates to mark-to-mark LTVs less than 80%. And Ryan is going to correct me in 2 seconds when I hand it over to him to talk about our recent announcements. With that, Ryan?
Thanks, Sujatha. So yeah, I will walk through the announcements without correcting you. So we can go to this first slide. We recently had announcements pertaining primarily to more COVID-19 updates, and then also there was an update around PAID as well. But the two primary announcements were to confirm that the foreclosure moratorium is coming to an end. So that will end on July 31st, so just a couple of days. And with CFPB, just a little bit earlier in the same week as our announcement came out, finalized their rule that would create some additional foreclosure requirements, and it's certainly not a full moratorium. So we are still considering this to be the end of the foreclosure moratorium, but there are certain restrictions that the CFPB rule would put in place. But the new rules wouldn't go into effect though until the end of August. So there is a 1 month gap period. So we wanted we basically say follow the CFPB rule, but 1 month early. And so what that means is there'd be no new referrals, but foreclosures on the foreclosure process on loans previously referred to foreclosure before the moratoriums went into effect back in early 2020 could resume. And then in other cases, there are certain limitations on when new referrals can be made. And most of those have to do with borrower evaluations for loss mitigation. The borrower has to have a chance to be evaluated. So for any borrower that has already been reviewed for loss mit and denied or didn't accept an offer, that would be something where you could move forward. And then also if the borrower is not responsive to your outreach and other situations like that. But basically the rules in place to try to ensure that borrowers coming off of COVID-19 forbearances and borrowers otherwise impacted by COVID-19 have a full opportunity to be reviewed for permanent solutions, and that they don't end up getting foreclosed on if their delinquency was caused by COVID-19 before they have that chance. So I think that's basically what the foreclosure announcement was. We also introduced adjustments to the FlexMod, which I think is probably the next slide. Sorry. Okay, so yeah, I think we can go to the next one here. So adjustments to the Flex modification where typically for a FlexMod, if you have a loan to value ratio that is less than 80%, you would not qualify for interest rate reduction. And we wanted to ensure that as many borrowers as we could account for would be eligible for the FlexMod. But in addition to that, we also wanted to ensure that borrowers who got the FlexMod were getting the kind of payment reduction that will lead to a successful modification. So for borrowers, again, where the delinquency was caused by COVID-19, so if they were current or less than 2 payments past due as of March 1st of 2020, and they're being reviewed in a streamlined manner, which is generally going to be 90 days delinquent, but it could also be 60 days delinquent if they had previously completed a COVID-19 payment deferral and then went 60 days delinquent within that first 6-month period. We have special provisions in place for that. Those borrowers would qualify for these special kind of COVID-19 flex mod requirements where they would get the benefit of the interest rate reduction as part of the flex mod waterfall. So really, to make this more simplistic, it's just the flex mod waterfall, with the only difference being that borrowers who have less than 80 LTV in most cases will also get the interest rate reduction lever pulled. So that's the flex mod change. We've looked at the numbers on our end, and it does look like that should really help almost every borrower get the help they need, even if they are as late as 18 months delinquent coming out of the forbearance. And so on the right here, I'm not going to go through it, but it's the regular flex mod waterfall with again, that's just one exception being that in certain cases, interest rate reduction will apply for loans with MTM LTV ratios less than 80%. Okay, next slide, please. And now I'm actually going to hand it over to Jonathan. He's going to cover how to submit the flex mod with the adjusted requirements into Workout Prospector. Jonathan?
Hi, thank you, Ryan. So good afternoon. So to reiterate what Ryan was saying before me, this change only really applies for the loans that have a post-mod MTM LTV less than 80%. So for your loans that have a post-mod MTM LTV greater than 80%, there really won't be any change to your process. You'll submit those through Workout Prospector as you do today, and Workout Prospector will automatically adjust the note rate to where it should be. But for the ones that have less than 80%, we're asking you all to submit these as non-delegated in Workout Prospector. So as part of that, what we're asking you all to do is to model the modification like you normally would, but we're asking you to add a comment into the comment section that calls out that this is being submitted for a note rate adjustment due to the borrower being impacted by COVID-19. And then we're asking you all to list a few of the terms of the post-mod, the post-mod terms, excuse me. The note rate, post-mod UPB, P&I, interest rate change date, and first payment due date. And these are all just to help ensure that we get this approved correctly the first time through. So once you have that comment in WP, you can hit submit to Freddie Mac to submit this for non-delegated review. So next slide, please. So we're just going to walk you through some of the screens that you'll see as you're doing this. So this is the mortgage attribute screen in WP, which you see once you put the loan into WP and select retention. This is where you're going to put in a lot of our, oh, I'm sorry, I'm speaking too low.
If that is better, thank you.
Okay, sorry, my apologies for that. So this is where you will put in your pre-modification terms for the loan, the current UPB, current P&I, and all of those things. Once you have all the information input onto the screen, you'll hit save and then also hit the next button, and we'll move on to our next screen, which is where you'll see the modeling attributes. Here is where you're going to fill out all of the applicable arrearages and capitalizations that are going into the modification. And this is also where you want to ensure that you select the National Emergency Declaration hardship for your COVID impacted borrowers. So once you have everything submitted on this screen, we'll hit save again, and then also move to the next screen, which brings us to our Modification Solution screen. Now, on this screenshot, you can notice that our post-mod MTM LTV here on the bottom right is less than 80%. We've got 36% here, but the new note rate on this says 4.75, so it doesn't represent a change. So what we're going to do then is we're going to use the link on the left-hand side of WP to go to the comments, and we'll go to the next screen. And we're going to put in that comment that I described earlier. And here we're saying submitted for note rate adjustment for COVID impacted borrower. We're putting in our terms that we're requesting. So post-mod note rate of 3%, the UPB, P&I, interest rate change date, and the first payment due date. So once that comment is saved, we're going to move through the model once more and come back to the Modification Solution screen. Now here's where we ask that you all just look at the terms that are on this page, just to make sure that the delinquent interest is correct and the total capitalized arrears are correct. Once you verify all of that, if you hit that send to FM button, you're going to get this pop-up that says, are you sure you want to submit this for negotiated review? When you hit OK, you will see this message pop up, which will notify you that the loan is currently being reviewed by a Freddie Mac analyst. You'll also notice that this green status pops up that says negotiation status pending negotiation, which just means that it's in Freddie Mac's queue and that someone's going to be picking it up soon. Next screen, please. So after you submit this, Freddie Mac analyst is going to pick it up and will review the comments and then adjust the model to the terms that you've put inside of the comments. Once the loan's placed in negotiation status approved, you can settle the workout via Workout Prospector as you normally would. Now, I do want to reiterate that if there are no other exceptions required for these loans, the modification will be approved as a delegated modification. So if there are fatal edits associated with the modification, you need to call those out in the comments so that we can address them in our approvals. And with that, I'm going to throw it over to Brenda.
Good afternoon. This is Brenda Short. I'm going to give you an update this afternoon for paid and resolved. So as we know, paid is coming on September 27th, and we just want to provide you with some updates in order to help you prepare for that onboarding. So we have some fantastic learning resources out there available to you for self-service. So you can access those through the paid webpage. You can also sign up for the upcoming live training. You can also look into the introduction and navigation, and then you can request for pre-approval. So there's a paid video learning series out there that you can access at your convenience, so we highly encourage that. Next slide, please. So we also have our onboarding checklist for paid, which is a end-to-end tool to help guide you from a step perspective and a timing and what you need to do as it relates to a successful onboarding for you and your team. You can access this through the paid webpage. Again, another great resource. And when you access the checklist, it's interactive, and it will give you the different sequential steps you're able to go through and understand the key items that you need to be focused on and the time that you need to be focused on. So I highly encourage you to go out onto the paid webpage, go through the interactive checklist, and you can also download it. There's a PDF button just to the right where you can download it, and you can just have that version available for you, and you're able to see end to end and just flow sequentially based on the activity and the date. So again, very easy to use. I highly encourage you to access that to understand exactly where you need to be in the process. Next slide, please. So we have provided, again, our paid bulletin for the paid updates. We provided that with the bulk file template update. So what changed as it relates to the expense code, it's now going to be a required data field. Where can you get it? Again, go to the paid webpage. You can access the paid training homepage from the paid webpage. And then why do you need this? So this is going to, again, prep you for the upcoming bulk upload submissions for paid, okay? So additionally, I just want to add another reminder, granting user migration reminder. So if you have logged on to the reimbursement system by August the 1st, so today and tomorrow, you will automatically be migrated over for access into the paid system. So we highly encourage that because that will be one less step that you and your team will have to do. So again, if all you have to do is log in, you don't have to submit a claim, and you'll be considered active. All active users will move into the paid system, ready for the go live on September the 27th. Next slide. Okay, so we want to give you all a resolve update. So latest enhancements in the latest release, which is going to come up on August the 2nd. Resolve will have a new user interface feature called by My Submission for setting your agency loans. We're expanding also our B2B integration capabilities with 2 new APIs that support the liquidation process for our short sales. So please take time to read the article to learn more about the important releases and just to really understand what's coming down the line from a long-term vision perspective. You can see that by hitting the interactive experience. Next slide. And I'm going to pass it over to Sujatha. Thank you.
Thank you. Cass, can you do the intro on the Q&A while I go over the Connect slides?
Absolutely. So we will be taking questions shortly. If you have any questions, please use the raise hand icon and you will be unmuted to ask your question. You can also use the Q&A box, which is located on the lower side of your screen, and we will read the question for you. Sujatha?
Thank you, Cass. So everyone, we are really, really excited to bring back our annual conference for self-servicers. It'll be held, it's a virtual event that will be held from October 5th and 6th this year. We have a great agenda on the servicing side, covering some of the topics you've been hearing over the year, but as well as some of the new and exciting things we're looking to do in 2021 and 2022. So we definitely encourage you and your team members to please join us. When we'll send out this deck, as you can see, the link is right there for you to register. You can pick and choose which sessions you want to come to. We have from, further details about paid, a demo of Resolve, all sorts of, discussion around supporting our different loss-mit solutions. So please do take the time and have your team and your team members join us. There's no limit on how many folks from your teams can join. So please encourage them, as it's a great opportunity to learn more about Freddie Mac and how we work with you. Additionally, right now in the next month, the webinars that are coming up are listed here to support the change that Brenda just mentioned as it pertains. If you are servicing any Govy loans, we are changing our process for modifications on FHA, VA, and RHS loans. So please do take the training, avail yourself to the training if you have any of those loans, to ensure before any of those loans need to have modifications, that you're able to support them. Additionally, as Ryan mentioned earlier, the foreclosure moratorium is going to end. We want to make sure that you and your teams have the muscle. It's been 18 plus months, almost 2 years since we've done some of this stuff. Want to make sure that you guys can, if and when needed, have some background on just how to manage foreclosures, as well as how to support borrowers prior to foreclosure to ensure that they have that they're awareness of the different options that they have. And finally, Brenda again mentioned it, please do take the time. We've put together really short videos, they're not very long, to help you and your teams get ready for PAID, our new expense reimbursement system. And finally, as these are the standard links we have for COVID, but absolutely we keep updating these with information. So I hope you have them bookmarked somewhere, but definitely make sure you keep these up and keep taking a look at them, because we keep adding stuff as new things coming up. Thank you, Cass.
Okay, so let's take some questions. We've had some come in. For anybody who has a question, just make sure that you're using the Q&A box, or if you would like to ask the question yourself, please use the raise hand icon and we will unmute you to ask your question yourself. The first question is, can you clarify how to handle principal payments made by the customer after a payment deferral is processed? Do we process a normal curtailment, or do we apply the funds to the deferral amount?
I can take that one. This is Ryan. So that would be, and generally speaking, that's going to get processed as a normal curtailment. So it would go into the interest-bearing balance and lower the interest-bearing balance. And then if requested, you can also do a recast to lower the monthly payment obligation after processing that curtailment. If a borrower specifically requests to have it applied to the non-interest-bearing balance, you can do that via exception. It's not the regular process, but if that's what they really would like to do, you can do it that way. And then also, and I saw this come up on a later question as well, but in terms of homeowner assistance funds or any funds at all, actually, that get applied on behalf of the borrower but are not from the borrower, we recently put out a bulletin giving some more guidance on that as well, and you would treat those funds as though they came from the borrower. So if you get funds from a homeowner assistance fund or from, let's say, a local church or anything like that, for Freddie Mac loans, we would have you treat those funds as though they came from the borrower and just get applied in accordance with the security instrument, the note, and the guide. So hopefully that gives some flexibility. And then I'm just going to, because this is so closely related to the other question, I'm going to address that too. There was a question that was later, if a loan is reinstated through HHF funds from state programs and the loan is under forbearance, do we have to cancel the forbearance? So technically, I mean, you'd be working with the borrower. Technically, that reinstatement would actually terminate the forbearance, but there's no reason that you can't go right back into forbearance, which would essentially be just continuing the forbearance. The process would be the same for you. The borrower says their hardship is ongoing. You can just continue to report the forbearance to us, and it would almost be the same as though there was no canceling the forbearance. So effectively, that's the way that it would be. The only reason that we have it so that that reinstatement via program funds like that would cancel the forbearance is really for alignment purposes. But in practice, it's kind of like you're not really canceling the forbearance, because if the borrower does need to keep going, you can keep going. It would just officially, I guess, be considered a separate forbearance event.
Hey, Ryan,
Great,
and this is John Felix. So, to Ryan's point on the curtailment on a payment deferral, and he noted that if the borrower sends in a curtailment, applied as normal to the interest-bearing portion, but if for some reason, as Ryan said, they want it to be applied to the non-interest bearing, we do have a field in our loan level file specifically for that. If again the borrower is adamant they want it applied to the non-interest bearing deferred UPB, there is a curtailment field in our Exhibit 60, which is out in the seller servicer guide, and the field is called deferred principal curtailment amount. So again, it would be in their best interest to be applied to the interest bearing, but if they were insisting on the non-interest, we do have a field, and it's in our loan level, and I'm sorry, Exhibit 60 in the seller servicer guide.
Thank you. The next question, can we begin sending breach letters to borrowers who are 60 plus days past due non-COVID-19 related hardship as of August 1st, 2021?
Hey, this is Ben Gottheim. So the answer is, there's never an easy yes or no to any question, right? But the answer is generally going to be yes. So, as a reminder, Ryan talked about our announcement that ends the foreclosure moratorium on July 31st. However, we did follow up with further instructions that says, starting August 1st, you need to early implement the CFPB rules, which go into effect at the end of August, which only allows certain loans to head down the foreclosure path prior to the end of 2021. And as a reminder, those loans are any loan that was 120 days delinquent or in foreclosure prior to the pandemic, or where the statute of limitations will expire this year, or a borrower who did go delinquent as a result of the pandemic, but has since come out, doesn't have another solution, and you've checked all the boxes and you feel comfortable going down that path. Those are the foreclosure rules. The question always comes up, is the breach letter, which is typically going to be an acceleration notice as required under the GSE security instrument, the mortgage or deed of trust, is that actually the start of a foreclosure, and would that be prohibited under your rules or CFPB's rules? And the answer is generally going to be no. You're sending out the breach notice because we require it as part of our guide, and because it's required as a pre-foreclosure step, right? If you look at the mortgage or deed of trust in your state, it's going to say that you must accelerate the debt before you can begin foreclosure. That said, there are some states that consider, the breach notice to be part of the foreclosure process, right? Because it's a state required notice, not just a general acceleration notice. And in those, in those states, you want to check with your internal counsel and you want to check with your local counsel, just to make sure that, you're on the right side of the law. In terms of Freddie Mac, you'll be fine either way. In terms of CFPB, I'd hate for anybody to be in their crosshairs because of any confusion there. So, our best advice is to contact local counsel and get their opinion whether or not the breach should be, would be prohibited under CFPB's rules. But otherwise, yes, there's no, we have no prohibition on sending breaches. We haven't this entire time.
Awesome. I have, it looks like a related question. With the foreclosure moratorium expiring, what is happening to the timelines and compensatory fees?
Yeah, so it's Ben. I'll take that one as well. Well, first is the answer, and then I'll share that we did put an update on our servicing gateway, and so hopefully you guys have seen that. But actually, I'll just put it all as one answer. Last week, we actually put out a communication. It was directly on the servicing gateway so that you'd all have access to it, regardless of what systems that you use or go into. And we hit on 3 things with the foreclosure moratorium, actually 4 things with the foreclosure moratorium now coming to an end. About foreclosure timelines and compensatory fees, we wanted to put a reminder of the same thing we've talked about on this call over the past 15 or so months, which is we set foreclosure timelines in alignment with Fannie Mae. That process is done annually at the end of each year, and we do that based on the most recent 12 months of actual data that we have that shows timeline performance, right? It's not, we don't market to anybody's best estimates or guesses. We use actual data. Obviously, we have no recent data. We have very few foreclosures. They're all on vacant abandoned properties, which are, obviously tend to skew to very quick timelines. So we have no data. So in terms of foreclosure timelines, what does that mean? It means we're not going to update our foreclosure timelines for at least 1 year after the moratorium is fully expired. Probably a little bit longer because, again, we're going to want to make sure that we have a full year's worth of foreclosure sale volume and data to be able to aggregate with Fannie Mae to ensure that we can base good timelines off of, so that they are realistic measurements in terms of your scorecard performance and overall requirements of our guide. So what does that mean? It means there will not be any updated foreclosure timelines until the end of 2022 at the earliest. And again, we'll have to check in over the coming months to see what the volumes look like. And then in terms of foreclosure timeline compensatory fees, again, our process is done annually. Servicers who are in the bottom 25% of their scorecard performance groupings may be subject to compensatory fees based on a number of different factors in the foreclosure space. But at this point, nobody has to worry about that because, again, we will not update foreclosure timelines until at least the end of 2022, which means there would be no compensatory fees to measure until at least the end of 2023. And again, probably will go longer than that, and we haven't issued any compensatory fees in the last couple years anyway. So, but we don't see it as a concern. We know you guys obviously have questions since it's always something that hangs out there. So want to be able to put that out there today that says no timelines until the end of 2022 at the earliest, no compensatory fees until the end of 23 or into 2024 at the earliest. So keep that from your mind. The other 2 things we put in this announcement on servicing gateway, again, these weren't policy changes, henceforth not a bulletin. They're just clarity and new information. So timelines, compensatory fees, also touched on the allowable delays. We've gotten questions from a number of servicers about our allowable delays. Will the COVID moratorium, will forbearance be considered an allowable delay the way bankruptcy is? Of course it will be. But again, this is GSE alignment, and we, and we have to work with Fannie Mae and FHFA in order to get there. So give us some time to get, to be thoughtful here and get that through. Again, there's not going to be foreclosure timelines to measure you to for another year. So, we're trying to update those as quick as we can as well. And then finally, as we discussed, a number of foreclosures can be resumed, right? We had, I'm sure some of you had foreclosure activity that was paused as a result of the foreclosure moratorium going into effect last March. Those files can be immediately resumed starting in August. Of course, you'll only resume them if the borrower is still not performing and is not on loss mitigation or forbearance. And if that is the case, you can work with your attorney to start that foreclosure back up in August in compliance with our guide, in compliance with CFPB's rules. And as part of that, we did issue a notice to you all and to the attorneys that you may submit a one-time foreclosure resumption fee of $300 for reimbursement by Freddie Mac. You have to do that via the RPA functionality. And you're going to have to do that via the RPA functionality and paid, as Brenda talked to earlier. So paid goes into effect at the end of September. And once you've adopted paid, you may submit on those files the $300 RPA, so that and that will account for any additional legal work that might be required by your attorney to take that file off hold and to begin the foreclosure process again. So make sure, if you have access to Gateway or work with your teammates that have access to Gateway, make sure you get download that. Communication has a lot of good information. It's probably easier to read than having listened to me talk about it very quickly over the last 3 minutes. So thanks, Cass.
No problem. And I just want to remind our audience that we have all the materials that we're going to be sending to you after the call. So if anybody was wondering that. But I do have somebody who has their hand raised. So Mark L., I am unmuting you so that you can ask your question. Go ahead.
Thanks. Ben, and getting back to your $300 fee, most of these foreclosures that were put on hold, our attorneys are going to have to pull updated title work for other liens, so that would be covered under that, correct?
So the purpose of it could be, right? But the purpose of the fee is really for the legal work in order to resume it, right? It's taking the file off hold, having to redo any motions or, again, I don't want to get into different state laws of what that might mean, but
right.
It's really the resumption fee. Title is generally going to be considered separate now. If your attorney can get all that done within 300, then just do it that way as opposed to two separate submissions. But the reality is probably not. And then if that's the case, you shouldn't need to run a full new title report at a few $100s a pop. You probably just need to do an update to cover, from March of last year till this point. And we do reimburse those at $75 a piece or slightly higher in a couple states that have higher costs. Generally, you don't need an RPA for that. If you are still within our allowable limit for the title expense that's described on Exhibit 57A, or if that update is due to bankruptcy. But for all other updates, if you're already over the limit or at the limit, or it's not bankruptcy related, which this would not be, then you can submit an RPA for that additional title expense. And Shuba, I know you're on. Let me make sure I said that correctly.
No, you did. I was just going to say that title allowable typically allows multiple updates. So if you are within allowable, you may not need an RPA. So before submitting RPA, you should check to make sure you have not exceeded the allowable.
Okay.
Yep.
Thank you.
Okay, and we have another person who has their hand raised. So Daniel R., I am unmuting you, so you can go ahead and ask your question.
Yeah, so I had a couple questions actually regarding paid. My first question is, I know you said the go live date is 9/27. I was curious if these servicers are going to get any access before that, just so we can kind of get used to with the the navigation and how it works and everything, kind of just get comfortable with it.
So the go live date of 9/27 is when you're going to have that's going to be your access. So as I mentioned earlier, that you'll be, if you're active now on the expense reimbursement system, you will be migrated to paid, and you will be able to access it on 9/27. So no advanced access before it goes live.
Okay, great. And then my second question regarding paid is I'm curious if the same GA date process is going to still be the same as it is with Vendorscape versus paid.
I'm sorry, repeat your question.
Yeah, so My question is regarding paid. And currently right now within Vendorscape, when you have like a third-party liquidation or a short sale liquidation, before the servicer can file that claim, there has to be a present GA date, the get actual date. And so I was curious if that same get actual date, that whole process is still going to be the same as it is today.
Brenda, do you want me to take it?
Yeah, go ahead. You can. Go ahead. Sure.
So
Go ahead, Shiva.
business-wise, the process is still the same, but we have modified how we get that date. So as long as you have a settled third-party sale, you would be okay to submit 104.
Okay, so going forward, once I'm guessing once the servicer receives the third-party funds, we can go ahead and we can file the claim. We no longer have to wait for the GA date. Is that correct?
The third-party sale should be settled. Yes, that's correct.
Okay, so just to confirm, so there won't have to be a present GA date system or a GA date in the new paid system, because today
Yeah,
we can't.
the new system does not have GA date.
Perfect. That's all I need to know. Okay, cool. Yeah, I just wanted to know that because that obviously changes like our claimable event on the back end. So I really wanted just to confirm that. So that really helps. Thank you so much.
All right. We have another person who has their hand raised. Allison L. You're being unmuted. Go ahead and ask your question.
Okay. Hi. So I had a question. We're processing our first ARM loan deferral, and we actually settled it in Workout Prospector on the 8th of this month, and we're still not seeing it settled just in the payment deferral status loan detail report. It's still showing pending settlement and also on the modification report as well. So I'm wondering, is there a different timeline as to when it will be settled, or is it just different because it's an ARM loan compared to a fixed loan?
Was the effective date in the following month? Because if sometimes people use like a additional processing month and the effective date is in the month 2 months out. So if the effective date is 2 months out, that's one reason why it would show pending. Because we only settle, we even if it's settled on last mid system, for our performing loan systems, we only give them the loans that are effective for the following month.
No, yeah, this one's effective for the following month, not 2 months out.
Okay, so maybe I will give you my information and you can shoot me an email afterwards, and we can figure out what happened.
Okay, perfect. Thank you.
Okay. So our next, question is, can you capitalize escrow shortages with COVID flex mods or payment deferrals?
So an escrow shortage cannot be capitalized under either one of those scenarios, only if you've advanced to cover actual bills. Those amounts you can include in the capitalization for a flex mod and then the deferred balance for a payment deferral. But for a shortage, we don't permit you to fund the escrow account and then to include that in either the capitalized amount or the deferred balance.
Great. Another question. Do we have to send the original modification to our document custodian vendor?
Yeah, so the short answer is yes. The longer answer is that there's kind of an if-then scenario, a set of like a group of if-then scenarios on those just for the details. And so I'd point you to our guide and to chapter 9206.17 specifically for all of the more detailed requirements on that. But again, the short answer is yes.
And just a reminder to everybody that you can do that electronically, especially if you're using an electronic payment deferral or modification.
Great. And I see somebody with their hand raised. So Blanca P., I am unmuting you so that you can go ahead and ask your question.
Hello, thank you. My question is, this has been an ongoing issue since we started the forbearance and the payment deferrals. I am not able to report a loan that has a deferred amount without getting an edit. Is there a better way to report those as a bulk? Because if I report it as a bulk file, and then hours later it comes out as an edit and I have to make the adjustment, is there a better way, or do you guys are aware of that issue that's going on?
I assume are you referring to your monthly loan level reporting file?
It's daily. Well, for us, it's daily.
Oh, yeah, yes. Yes.
So this is John Felix. So what edit are you receiving? Do you know?
I am receiving 3 different edits on that same loan, 711, 700, and 816. And I've sent that over to
816. What was the other one? I'm sorry. 700, did you say?
700, yeah,
Okay.
Correct.
Come on, John. I know you got all the edits memorized by now.
And you sent it over. You sent it over to your IR rep here.
Yes, I've actually sent that out a few times, and then also FICS did also reach out. They did make an update, and that is the file is failing, and I made the corrections, and I'm still having this issue since we started doing the payment deferrals. And when the loan pays off, it's never right. There's always an edit, or I have to manually report it.
Okay. Yeah, you know what? Because I was working with FICS Matthew Perez.
Yes.
That sound right?
Yes, that's correct.
Yeah. So I provide. Is this One Choice?
No, this is On Point.
Oh, On Point. Yes, that's what it was. It was On Point. On Point. Yeah. I followed back up with Matthew. So I'll get you my contact information. I sent Matthew a note saying, did you resolve? I kind of gave him some information, probably specific to a loan, and it was probably this loan. And I hadn't heard back from him. And I reached back out and said, "Hey, are we good?" And I haven't heard back from him yet. So, and I asked him who is the servicer and contact information. So, I'll get your contact information or provide mine, and then we can talk directly.
Okay, that's fine. Thank you.
Yep. Thanks.
Awesome. We do have another person who is on the line with their hand raised up. Robin T. I'm unmuting you so that you can go ahead and ask your question.
Hi, thank you. This is in regards to an auction that we actually had scheduled March of 2020, and the moratorium came out just at the same time. It is an occupied property, and therefore we in the state of Maine had to file extensions in the court every 3 months to extend the time to publish the sale. As you know, it's a moving date, and now that we're hitting that moratorium, we'll be able to schedule. My question is with paid not going live until 9/27, I am going to have multiple RPAs for all these additional filings in the court just to keep our foreclosure alive till we could get to auction. Is that going to be a problem since I anticipate the auction will take place prior to paid going live?
I'll ask Shuba to weigh in as well, but no. The answer is no. If you are not able, right, we have a blackout period before paid goes live. If you're not able to submit RPAs or claims during that period, there's not going to be a penalty or oops, it's too late because we made you wait, right? That would be an absolutely horrible experience. That's the opposite of what we're trying to accomplish. So no, you can submit those. You can submit those once you're live and on paid, ready to submit.
Okay. And should I be submitting the RPA prior to filing the claim when it goes live, or just file the claim and provide the backup as a outside of exceeding expense for foreclosure legal fees?
You would need to submit that as an RPA, even if it is after the fact.
Okay, thank you.
But Shuba, she'll be able to submit that as, if there's multiple of these, she'll be able to do it the submission at one time for all of them, right? That's some of the flexibility.
Yeah, it's like that's the beauty of paid. It's like there is a file format and it's very simple. Like it's something you can create in Excel and just upload it. So it's not going to be like Vendorscape where you have to enter one RPA at a time.
Yeah, you're not going to have to take an entire day to do RPAs for us here.
Oh, great. Next question.
I just want to add to that about the RPAs. This is Brenda Short. Just to understand that the last day to enter your RPAs for the blackout for the expense reimbursement system is September the 10th. And you would just hold those, like Ben mentioned earlier, you just hold those. It's not going to be a penalty. When you get live on page, you'll be able to submit those RPAs at that time.
That's correct.
Great. One question is asking for a clarification. Just to clarify, if we receive a curtailment, any curtailment funds from the borrower, we must apply the curtailment funds towards the non-interest-bearing UPB instead of the interest-bearing UPB.
So no, that's no. Yeah. Again, the short answer is no. it would be applied to the interest bearing. I mean, ultimately there's nuance to this. It's going to be applied in accordance with the security instrument of the note, and so timing does come into play if there's already arrearages. Like let's say for example you got a contribution from homeowner assistance funds and the payment deferral hasn't yet happened. And maybe you don't even need to do a payment deferral. Maybe you're able to apply the funds to all the past due amounts to reinstate the loan. But assuming that you've done a payment deferral now, the loan is current, and you get funds, you can apply those you can apply those funds to the interest-bearing balance. And then if the borrower also wants to recast the loan, and you can do that as well to provide some level of payment relief. Same thing would apply if it's a flex mod. If the borrower gets a flex mod, is now reinstated, but they've been evaluated, they're working with a state HFA, and there's additional funds that are made available to help even further offset the hardship by lowering the payment even more. You can even do a curtailment there, and then again, you could even recast the loan again and further reduce the payment even beyond what the flex mod offers. So there's it depends on timing, but it's always going to be applied the same way you'd apply it if the borrower just said, here's a bunch of money that I have now, you'd apply it the same way.
Thank you. Next question. Borrower is 18 months delinquent and already used the 18-month forbearance. He states that he still cannot make payments. How do we proceed?
So on a delegated basis, you would not be permitted to approve a forbearance that goes beyond 18 months of delinquency or 18 months in term. If you have reason to believe that even though this is now at 18 months, it is still a short-term hardship going forward and that this borrower would be able to reinstate at some point, you can always submit exception requests as long as you can provide that justification for why this particular case merits the exception. I would say in many cases, once you get to that level of delinquency, it's less likely that this is still considered a short-term hardship or not a permanent hardship. But if you have information that leads you to believe that it is, and that the borrower can eventually reinstate the mortgage, then you can submit that with your justification, and it can be approved on an exception basis. But you would not be delegated to approve the extension of a forbearance that goes beyond 18 months delinquency or 18 months in forbearance term.
Great, and I see someone with their hand raised. So Maria G, I am unmuting your line so you can go ahead and ask your question.
Hi, thank you. So my question is for borrowers who are non-responsive. Their COVID forbearance has expired, and our next step would be after August 1st, basically, to start our foreclosure process. Do we need to breach them before we can file the NOD?
So two things to your question. One, just keep in mind CFPB in their rules, which we told you to early adopt starting August 1st, has some details that are fairly explicit as to what they perceive to be non-responsive. And I want to be clear that make sure you're following those rules, right? We don't want you to try to force something in that's going to violate CFPB because they're going to come after you, and that's going to be a problem. So make sure you're complying there in terms of in terms of that. And then in terms of a breach notice, generally first, I'm going to assume here that that you haven't previously breached or accelerated the debt before the moratorium or before this point. If you have, you might, depending on the state law, you may not need to send a new notice. If you haven't, you would need to send a new notice. And again, it gets messy when you start talking about different states and different rules, right? In some states, the NOD and the breach notice are going to be considered the same thing. So again, work with your local council. If they are in fact one of the same, if you normally accelerate the debt as part of your NOD, then yeah, you would do it that way without having to send an additional notice. And again, make sure that's complying with CFPB's rules. Hire a lawyer, make sure they answer these questions. Otherwise, you would send out the acceleration notice.
Okay, perfect. So yeah, I'm referring to borrowers who have never been in any part of the foreclosure. They've gone into COVID forbearance, and when we're reaching them, and they're just not responsive to a post-workout option, basically to bring their loan current. So I wanted to know those. Yeah. All right, perfect.
And when you
Thank
say, and one more, if you say not responsive, I just want to be sure you're talking, right? So there's not responsive in terms of your calls and your email campaigns and all the stuff you're doing there. But then for non-responsive borrowers, the proactive offers. Yeah, great, perfect. Make sure those are done. Again, I want to give a reminder to everybody else, right? CFPB put out rules. CFPB has made statements that said that they're going to make sure that you all as servicers are giving borrowers every opportunity to avoid foreclosure. So keep yourself safe. Make sure you have your T's and I, your T's crossed and your I's dotted in terms of your procedures before you undertake any foreclosure actions, especially before the end of 2021.
Perfect. And then if I can just ask a follow-up question. So with the deferral, I know that we can offer them the deferral once the forbearance has expired, regardless if we should solicit them for that. What's the time frame that we can give them for them to respond to that? Is it 2 weeks or 30 days?
So in the payment deferral offer, the borrower has to accept within the same month offered. So it would just be, technically, I guess it's 2 weeks, but you really, if you send the offer earlier in the month, it can be any time in that month. With the flex mod offer, it's a little bit different actually. It's because they have the ability to make a payment on the trial period plan. We say to respond within 14 days, but that's really a soft requirement. And I would consider that offer to be active on a flex mod until the borrower has gone the full month where that payment is due without actually responding to you or making a payment. So yeah, okay.
Okay. All right, thank you.
Okay, another question. The White House today put out a statement asking government agencies to extend the eviction moratorium. Does that impact Freddie Mac servicing?
Oh, that's a great question. Thanks, Cass. So yes, for those who haven't seen and aren't required to read White House press statements all the time, like we are, yes, the White House put out a statement today urging HUD, USDA, and VA explicitly to extend their REO eviction moratoriums. As the CDC's eviction moratorium, the much broader eviction moratorium that the CFPB has, CDC has done, expires at the end of this month, and the Supreme Court has said that cannot be extended. So I don't know what the government agencies are going to do in terms of Freddie Mac and Fannie Mae. I can't say anything definitively until FHFA says something definitively, but I'm sure they're working together with the government agencies to consider extending the REO eviction moratorium through the end of September. For you guys as servicers, that's not going to have an impact. This is not an extension of the foreclosure moratorium. This is not any other type of moratorium that you'd have to deal with. This would simply be for any loan that is already REO or becomes REO before September. We as Freddie Mac may have to postpone any eviction activities until the end of September. Still to be determined, but there would be no impact on you guys as servicers either way. You would still continue to proceed as you would proceed regardless of this.
Great. We have time for a few more questions. I just want to let the audience know if you have any questions that we did not get a chance to answer today, we will either talk about them on the next call or follow up with you in the interim. So the next question is, are we still okay to offer COVID-19 forbearances for new consumers that are getting affected by the pandemic?
Yes, we have not. We have not set any expiration date for our COVID-19 specific policies. So if a borrower comes to you and hasn't been on COVID-19 forbearance, they're eligible for up to 12 months as of today. And then, of course, the extensions have a little bit of more requirements related to them. And so I'm not going to get into that unless I have more questions about it. But even if a borrower has already been on COVID-19 forbearance and come off it and maybe reinstated it and then comes back to you and they're eligible for more forbearance, they can still get it under the COVID-19 forbearance policy.
Great, and it looks like something that's similar. Are we still monitoring whether the borrower was on a COVID forbearance in February 2021 in order to get 18 months of forbearance?
Yes. Yes. So for a borrower to get that first 12 months, that's not a relevant requirement. But if the borrower is going beyond 12 months of COVID-19 forbearance, they would have had to have been on an active forbearance plan in February.
Great, and I am going to throw a poll up so that audience can answer the poll while we continue to answer at least one or two more questions. We have a lot of questions for today. This question is, we have a borrower who has exhausted all workouts and failed the last Freddie approved exception workout. Prior to COVID, we had sent the breach letters, but we were unable to refer due to the moratorium. Are we able to refer September 1st, 2021, or do we need to do something else prior to or wait until a later date to refer?
Oh, you're not going to like my answer, but it's going to be to talk to your attorney and make sure that there's no other prohibitions or anything that's standing in your way. But my reading of CFPB's rules would be you've offered them all potential loss mitigation. They have no loss mitigation that continues to be available to them. So regardless of anything else, they should be eligible to proceed with foreclosure before the end of 2021, based on the information that you just provided. In other words, you would be able to do that. But again, make sure you're talking with your in-house counsel, local counsel, making sure that you're not violating any of those rules. But it would seem that would be the case.
All right, we have time for one more question. And again, to remind the audience, if we did not get to your question today, our apologies, we just ran out of time. We will follow up with you before the next call. So the final question, in the new chapter 9201.1, it states that servicers must cancel an active forbearance plan, repay plan, or payment deferral if the mortgage is reinstated as a result of mortgage assistance funds. This is concerning for borrowers on a COVID forbearance for whom we have not committed their hardship, confirmed that their hardship is resolved. Was that considered?
Yeah, so I think this is similar to a question from earlier. So because there's no longer a delinquency, I think the thought here is that it's technically the forbearance would be over because of the reinstatement, but there's engagement with the borrower, and if there's an ongoing hardship, you would continue with the forbearance. It's just that because the loan has now been reinstated, we just want to make sure that you're in contact with the borrower and making sure that there is still an ongoing hardship there, and there's no reason that you can't continue with the forbearance, but it would have to be based off of that continued conversation or continued contact with the borrower to verify that there is still a hardship, even though the loan is reinstated.
Ryan, if you say that a little bit differently, right? It's, regardless of whether you call it a continuation or you call it a new forbearance, the fact that you received those housing assistance funds and applied it, and it has at this point brought the loan for the time being current, does not prevent or prohibit the borrower from being eligible for forbearance. The borrower still remains eligible for forbearance if they are not able to meet their monthly payment obligations going forward.
Thank you, everyone. We're coming up at rounding out the hour. Thank you to all our panelists today for answering all the questions and giving updates. Thank you to all our participants for taking the time to join us. If we were not able to get to your question, we will find a way to get a response to you. Definitely, as Cass mentioned in the beginning of the call, the recording of this call and the presentation will be sent to you sometime next week, so you can have that for your records as well. Thank you so much, and we look forward to seeing you on our August call.